Hello, my name is Ken Burke, and I'm your elected Clerk of the Circuit Court and Comptroller for Pinellas County. We have created a series of videos to assist you with completing the forms or packets that you will submit to either initiate your case or address issues that have arisen in a pending case. To ensure that your documents are processed quickly and efficiently, it is important that the documents are completed fully and properly. This short video will take you through the forms or packets as well as answer some of the most frequently asked questions. At any time, please feel free to pause the video and take a moment to fill out the applicable section. Once you have completed the form or packet, please refer to our website or contact our office for instructions on how and where to submit these documents. Should you have any additional questions regarding a family law, small claims, or landlord-tenant case, affordable legal services are offered through the Clerk's Self-Help Center. Please visit our website at www.mypinellasclerk.org for additional information. Thank you.
To initiate a simplified dissolution of marriage, you and/or your spouse must be a resident of Florida for at least 6 months prior to filing. You and your spouse should agree that the marriage cannot be saved, have no minor children or are currently pregnant, have agreed on distribution of any assets and liabilities, and will appear together to file the case and attend the final hearing. If you do not meet the criteria above, you must file a regular petition for dissolution of marriage. While a clerk of court cannot provide legal advice, the Self-Help Center has attorneys on hand for a reduced rate to assist with any questions for parties representing themselves. Go to mypinellasclerk.org to find out more information on assistance for self-representation. First, let's go over the information that is required on pleadings filed. The header must include the location of your case by entering the judicial circuit and county. Pinellas County is located in the 6th Judicial Circuit. The case style states who is the petitioner and who is the respondent in a lawsuit. The person who originally asks for legal action is called the petitioner and remains the petitioner throughout the case. The person against whom the original legal action is being requested is called the respondent, because he or she is expected to respond to the petition. Your case number is a unique number used to identify your case and is assigned in sequential order in the court it is filed in. This will be provided to you when you file your case. A case number may be referred to as a reference number, UCN number, or case number. Always remember to sign and date any filing where a signature is required. Some forms, such as affidavits, are notarized documents. Wait to sign these documents until you are in the presence of a notary or deputy clerk. Please bring photo ID with you. When you file a document with the court, you must also provide a copy for the other party. Be sure to put in the correct information of service on each form. If someone other than an attorney in good standing with the Florida Bar Association helped you fill out a form in this packet, enter their name and contact information on the forms that request it. Read all forms and complete the required fields. Please make sure to provide accurate information and print clearly. All questions need to be answered. This form must be used when anyone who is not a lawyer in good standing with the Florida Bar helps you complete any Florida family law form. Attorneys who are licensed to practice in other states but not Florida, or who have been disbarred or suspended from the practice of law in Florida, are non-lawyers for the purposes of the Florida family law forms and instructions. The non-lawyer must complete this form and must be signed by both you and the person assisting you before completing any family law form. Florida Rule of Judicial Administration 2.545 Section D requires the petitioner in a family law case to file with the court a notice of related cases, if any. A case is considered related if it involved the same parties, children, or issues and is still pending when the family law case is filed. A case can also be related if it affects the court's jurisdiction, or an order in the new case will affect an order on the same issues in a different case. Always read through the entire motion before filling in information in the fields provided. Check the box that applies to your case. If there are no related cases, check the appropriate box and proceed to sign and date the notice. If there are cases related to your action, list the case information in the provided fields. Check the box that corresponds with the related case type. If none of the options apply, use the other box to enter the case type. Check the box as to where your case was filed. Fill in the state where the case was filed if it was not in Florida. Fill in the name of the court and the last order or judgment filed in the case. For example, if your case is in Pinellas County, the name of the court would be the 6th Circuit Court, Pinellas County, Florida. Next, check the boxes that apply to the relationship between the two cases. Include further detail of the relationship below. If you have more than one related case, list each one separately in the spaces provided. If you would like the related cases to be coordinated between the two courts, check the appropriate box and list the case number in the space provided. Check the box that best fits your situation. If you are unsure which one to check, you may need to consult with an attorney. Remember to sign and date the completed form. Next, you will fill out the Family Law Cover Sheet. This document is used for reporting judicial information pursuant to the Florida statutes. Place a check beside the proceeding you are initiating. If you are simultaneously filing more than one type of proceeding against the same opposing party, such as a modification and an enforcement proceeding, complete a separate cover sheet for each action being filed. If you are reopening a case, choose one of the three options that correspond with the motion or petition you are filing. Check the box that most closely matches the action you are filing. If you are reopening the case for further action, this section can be left blank. Check the box that correlates to your knowledge of related cases. Complete the signature, printed name, email, and date. This form is used when a married couple are filing for a simplified dissolution of marriage. In order to receive a simplified divorce, you and/or your spouse must be a resident of Florida for at least 6 months prior to filing. You and your spouse should agree that the marriage cannot be saved, have no minor children or are currently pregnant, have agreed on distribution of any assets and liabilities, and will appear together to file the case and attend the final hearing. If you do not meet the criteria above, you must file a regular petition for dissolution of marriage. Please verify you meet criteria prior to filing. If the party wishes to be known by a former name, the party will need to include the name they wish to have restored. The parties should complete designated signature blocks. Please print clearly. This form will aid the court and the clerk in identifying related cases. This form is required to be completed and should be filed. Fill in the required fields. Remember, the petitioner is the party who is initiating the action. Please check the answer that applies. Even though a simplified dissolution does not allow for minor children in common of the parties who are filing, one or the other party may have a minor child from a prior relationship. Answer the questions for each child born to this marriage as required on the form. Answer the questions for each child not born to this marriage as required on the form. This form must be completed by each party. The information within the form will remain confidential, per Florida Rules of Judicial Administration 2.420. Complete the statement with your individual information. Select the option that applies. In a simplified dissolution of marriage, there should be no minor children in common to the parties who are filing. You will not need to complete the block provided to list minor child information. This form must be notarized. Wait to sign it until you are in the presence of a notary or deputy clerk. This form may be used to corroborate residency in a dissolution of marriage proceeding. Either party is required to have been a resident of Florida for at least 6 months prior to filing. Residency may be corroborated by a valid Florida driver's license, Florida ID, or voter's registration card which reflect an issuance date of at least 6 months prior to the date of filing, or the testimony or affidavit of someone other than you or your spouse. This affidavit is completed by the person who is confirming the party's residency in the state of Florida for at least 6 months prior to the filing of the case. This document requires signature in the presence of a deputy clerk or a notary. Please wait to sign this document. Please have a photo ID available at the time of signing. This agreement is used to settle once and for all what is owed to each other, what you can expect to receive from each other, including all assets and liabilities. This document may not be needed depending on the determination made within the petition. See Question 6 on the Simplified Dissolution Petition. Fill in the spouse's information on the required line. Input the date of the marriage. Read the statement and list the assets for that party. This will be done for questions 1 and 2 under this section. To avoid confusion, describe each item as clearly as possible. List only the last 4 digits for account numbers. Read the statement and list the liabilities for the appropriate party. This will be done for questions 1 and 3 under this section. List only the last 4 digits for account numbers. These items would be listed in your financial affidavits under Section 3. You may list division of those items here. Each party forever gives up any right to spousal support. Spousal support, also known as alimony, is not applicable within this case type. Any additional agreement made between the parties can be recorded in this section. This form must be notarized. Wait to sign it until you are in the presence of a notary or deputy clerk. Currently, the clerk provides the final judgment to the judge for signature. However, this may be subject to change in the future. Please bring self-addressed stamped envelopes to your hearing. A certified copy of your final judgment will be provided to you by mail using your envelope. The final disposition form is currently not required to be provided by the parties. If you have any questions about filing your case with the Pinellas County Clerk's Office, please contact us at 727-464-7000 or make an appointment to speak with an attorney at any of our 3 self-help centers.